Okay. Oh, I think this is working. It looks like we are live. What's going on, everybody? My name is Zach. I am the founding attorney, the founding partner at Press Start Legal. Tonight is the first Ask Me Anything brought to you by Press Start Legal. We are being broadcasted right now via Google Hangouts through YouTube Live. So we are going to just hang out here while we get a few more people in. I think the chat is working. If not, sorry. Somebody throw out some questions in the chat, and we'll get to them in a second. So you guys, we're in my home here in Hollywood, Florida. A little gloom and doom outside, but this is my home office. So live from Florida. We did get some questions via Reddit earlier today. We can bring those up here. So we got kind of a really crazy one right before the start of this. And I kind of want to bring it to everyone because it was really one of those out there questions. I don't even know if I can give a full answer to it, but I feel like I at least should do this guy the honor of kind of kicking this thing off with this sort of question here. So this is Mall Designs. He's on the game design subreddit. He writes, he has a gaming router. The company of which purchased the router from promised that he would get continued support of this particular software for the length of the router. And so far it has, according to Mall Designs. What happened is this company promised a new operating system, and it would fix a lot of the different issues people are having and complaining about on their forums, and they've passed their original deadline by some time. They keep claiming hardware issues and whatnot. Hours before it was supposed to release the new operating system, they delayed it again. He says it's been 70 days since that delay, and they refuse to answer any questions or give any information about the delay, but yet they still advertise their router with the tagline of the OS being released soon. So he wants to know if there's anything that he could do or a group of individuals who have this router can do to force this company to answer his questions. And that just kind of threw me through a loop. I mean, sure, there's all kinds of things you can do. You can go the typical route of blasting them on the internet if you want to go a very non-legal route. I mean, if you remember back, there was a lawsuit filed against PlayStation 3 and 4 owners, by 3 and 4 owners, suing Sony because when they purchased the PlayStation, they wanted it for a particular operating system. They were going to run Linux on it because when the PlayStation 3 actually was first announced, it said that you could run and install Linux on it. In a later update, they actually removed that feature, and what ensued was a class action lawsuit. So theoretically, based on that case, you could gather everyone up who bought this router for this particular reason, and you could theoretically file a class action lawsuit against them. Would I recommend it? No. Will you get anything out of it, let alone find an attorney who would take that case? Probably not. But you know what? Why not? Go for it. If you really care that much about this operating system, and I mean, that's why you bought this product, then I don't see a reason why not to fight for it. On a non-legal standpoint, my own personal advice, what I like to do when I have issues with companies, go on LinkedIn, find the highest level executive you can, and then see if you can locate his email address. A lot of the times of a particular company, you could Google who that person is and you'll find that email address. Send them a strongly worded email. You'd be surprised on how quickly they will write back. So that was probably one of the most out there, non-really video game related question that we received today. But he said it's midnight where he is, and he wanted to at least see if there was something he could do. I also assume that this was United States law that I was sort of giving you the option. That's where they filed the class action against Sony. But if it's midnight where you are, I don't think you're here. So, good luck. Anyhow, so we had a few other questions that came in before the live stream. Somebody asked, is it legal to use music for a non-profit fan game? They're talking about a game where the music is the protagonist, like an interactive fan-made video clip, not an ambient filler. I don't think I truly understand his question. Can you use music for a fan-made project? Now, are you talking about a game like, what's that new one that just came out in VR, the lightsaber game, where the music is actually the point of the game? No, not if that music is not royalty-free. You need to purchase a license to use that in your game. Whether or not it's a fan game or not a fan game, the fact that you're using someone else's potential copyrighted work, that's going to cause you some problems. As far as the rest of your question, even if the music is the character, I don't really know how you could pull that off, but yeah, it's the same issue. Anytime you're using something that is someone else's copyrighted work, do not put it in your game without a license. You're just asking for problems. On pressstartlegal.com, we put out a blog about a week ago all about fair use, because what I see on Reddit a lot is people talking about fair use and how almost every question of, can I use this in my game? Somebody responds with, sure you can, it's fair use, go for it. No, it's not fair use. 99% of the time, you will not fall under fair use. You will not be able to assert it as a defense, and it will cause you a pretty significant legal headache. Don't do it. And that's my rant on fair use. All right. Someone writes in, does use confer any sort of ownership by default? For instance, if on my personal site, I put up a demo that I think is a neat showcase of my skills. I don't put up a TOS, terms of service, or an EULA, end user license agreement, for whatever reason, and someone comes in and builds a business around that demo I somehow show. So he wants to know if he has any rights in that. So let's break this down. We're going to talk about copyright here. So when you create something that is a copyrightable work, you have what's called a common law copyright. It is created as soon as whatever you have made is put onto a fixed medium. If you're writing a song, as long as that song's on sheet music, you're good to go. If you record it, you're good to go. That's a fixed medium. In a game, you're creating something on the computer that is saved into a file. That's a fixed medium. As soon as you do that, common law rights. What is common law rights? It means that you have the similar rights to having a registered copyright, meaning it's yours, you have use, you can not allow people to create derivative works, etc. But you cannot enforce your rights until you have an actually registered copyright. You need to register it with the Copyright Office. It's copyright.gov. Really inexpensive to do so. And once you actually have that registered copyright, you can then go to the court system to enforce your rights. So I hope that kind of answered your question. So does use confer any sort of ownership? Use, no. If it's something you created, creating it is what confers the ownership. Let's see. Do we have anything new in the chat yet? Does not look like it. All right, guys. So send in the questions, throw them into the chat. I will do my best to answer them. I will keep scrolling through Reddit, some of the other questions that have come in. For those who don't know, our username is pressstartlegal. Oh, we just got something in here. Your stream doesn't have any sound. Nobody can hear you talking. It's been like this the entire time. I actually don't have anything in the chat. Okay, yeah, I got people telling me you guys can hear me just fine. Not really sure what that guy's talking about. If he's still listening, you might want to check the settings on your sound. that's all I got for you. All right. So this isn't Ask Me Anything, guys. Ask me questions. You're here because you want to learn about the law, learn about video game law, and I'm here to provide you answers. So ask away. I will do my absolute best to answer them. This is going on until 8:30 p.m. So 10 minutes down, 50 minutes to go. So this was a question that came in on Reddit from Juju Bean. Juju Bean writes, should devs focus on finding a game-focused law firm, or will a corporate one work? Now, I answered this question earlier in the day on Reddit, and the issue for this is, and this is how I explained it, a video game law firm like Press Start Legal, we are expertise in this industry. We know all the nuances. We understand the terms. You don't need to explain things to us. We also, most of us, get into this because they have a passion for video games as well. We can file your trademarks, file your copyrights. We can help you get incorporated if you're a brand new company. We can do all these things. Now, a corporate-based law firm can do all these things as well, but will they have the knowledge of the industry? That's up for debate. Will they have or understand all the nuances with the video game industry? Again, up for debate. Some might have an attorney who specializes in that in their firm. It's also possibly that you're just going to be dealing with a general corporate attorney. Not to badmouth any of them. It's just having someone who specializes in your industry versus someone who just understands business law generally. The way I kind of explained it to them was, you can buy a video game at Best Buy, you can buy a game at Walmart, but will the people in those stores have the same level of knowledge of that game as, say, walking into a GameStop? Similar to law. You can go to a video game attorney, he will understand your industry, he will understand the nuances of your games, he will understand what you and your company need to move forward. You can get that similar skill set at a corporate law firm, but you might not get that amount of detail and expertise in this. Shiloh writes, enlighten us, please, on the reason for where to incorporate versus federal law for MMOs and such. Okay. I think I understand your question. If not, try to rephrase it. You're asking the reasons on why your company should incorporate in certain areas, and you want to know versus federal lawyers for MMOs and such. Well, I'm going to only answer the first half because I don't really understand the second half of that question. So the reason why you want to incorporate in a particular state truly depends on what those states' laws, most importantly, what those states' tax implications are, and even in some circumstances, employment issues. Delaware is one of the biggest tax havens for corporations. A lot of the times they go there to file, and most of the time, not all, most of the time, if you're a startup and you're looking for investments, in my experience, I find that most investors will not talk to you unless you have incorporated in Delaware. That's just my 2 cents on the issue. Now, you can always incorporate in another state like Delaware and still have your principal address and your principal place of business in another state. For example, your home state. So, for example, we're down here in South Florida. If I were to create a new tech startup that makes new microphones, I would incorporate in Delaware and make my principal place of business in Florida, and I would file in Florida to get a business certificate so I can conduct business within the state. Okay, we got another question here. Can I get a copyright on an in-game username that I use in every game I play? Yes. Yes, you can, but it's not a copyright. It's a trademark. So this is a big deal for esports players, for online streamers, for people who are on YouTube. You can create a trademark of your brand. If you're known by a particular gamer tag and you're selling t-shirts, your website, you have a fan club, you're getting donations on twitch.com, you can trademark that name. Now, there's some variances to it. It can't be too descriptive. Chances are won't be here. You have to be using that name in commerce. So you have to be selling something or getting money in exchange for a service. So you got to be selling some type of merch, and you have to be selling ads. You have to be using it to receive some sort of funds. Another particular reasons why you want to trademark is protection, brand protection. That is your brand. You want to go out there and you want to enforce people who are using your brand without your permission. That's a big deal. But I know a lot of the times people don't like to hear that intellectual property is being used as a sword. You do have your copyright trolls and your patent trolls, but it's also your shield. I mean, you're having that mark is exclusive to you, especially with a trademark. You can keep a trademark renewed and continue its use as long as you are actively using it in commerce. Unlike, say, a patent or a copyright, which actually expires. So protect your brands. That's one of the best pieces of advice that I can give all of you, whether you're a streamer, a publisher, a producer, a developer. Protect your brands. We just got someone else writing in on the chat. We can't hear your live stream. Someone else is writing in. I'm not sure if you'll read this in time. We cannot hear you on live stream. Are you sure you guys can actually hear me? Because that's now 2 people who've written in that they cannot. Not sure what's happening with that. Yeah, people are writing that they can hear just fine. So again, check your settings with your sound. Not really sure. Not really sure what's happening there. But I have 2 other people also checking on whether or not they can hear me. Again, this is the first ever Press Start Legal. Ask me anything. There's going to be problems. Sorry, people on Reddit who can't hear me. The microphone's engaged. I can see myself on YouTube. Check your settings. Anyhow, okay, there was a mention of terms of use and end user license agreements in one of the questions. What are some of the protections these provide? And are there any gotchas when these settings up? Not really sure what the end part of that question is, but we'll start with the top part of that. All right, terms of service and user license agreement. A lot of these times, these are used interchangeably. We're going to tackle end user license agreement first. I'm sure everyone who's tuned in here at some point saw the very big dialog box that pops up when you install software or when you start a new game, create a new account somewhere. You'll see this very, very, very long, very convoluted, detailed agreement that you don't even read, and you scroll to the bottom and press I accept. But if you read it, you'd understand there's a lot of things in there that you are agreeing to. Now, the end user license agreement is a set of rules in which you, the licensee, agree to uphold by the licensor. Let's use a great example, Fortnite. One of the most popular video games out there right now. I'm sure most people in the chat have heard the story how Epic Games sued a 14-year-old kid. In fact, there's a blog post about it on pressstartlegal.com. And they sued him because he was using an aimbot to bypass their game's code and cheat. And no developer likes a cheater. It's bad for business. It hurts your game, hurts your reputation. So they sued him. And they sued him on many different counts, but one of the biggest and most important here is breach of contract. So you as a game player don't actually own anything. You are granted a license by the developer to use that piece of software. And that end user license agreement is that license. Those are the terms of that license. So in the Fortnite example, that 14-year-old kid was breaching that license. Epic Games revoked the license by banning his account. He then attempted to circumvent that, which led to a lawsuit. Now, terms of service, similar to an end user license agreement, but a terms of service is more often used with your actual website than the game. And that's the terms of the service you're going to be supplying somebody would be a great example. So terms of service, if your site not only creates and markets your games, but sells your games as well. Your terms of service will control things like credit card processing and refunds, shipping. You'll have terms and conditions in your terms of service that set forth things like price changing, information being accurate versus inaccurate. If you guys go down right now to the Press Start Legal terms and conditions section at the bottom of the page, that would be a great example of a terms of service. Those lay out the terms of your use of my website. Let's check Reddit again. That's two people sending me messages about the sound being off, but you guys are all telling me that it is working. So I'm trusting the chat on this one. So do we have any new questions coming in? Any topics that you guys want to discuss? This is anything you want to know, anything you want to hear. We will discuss it here tonight. Okay, here's a question that just came in. So we just got a call that says your sound hasn't been working the entire time. Read your chat. I'm at a loss because the microphone's showing me that it's working. You guys are telling me that the sound is working. But yet individuals keep telling me that it's not working. Hang on, we're getting another message coming in. That's another person telling me that they can hear me. So I'm sorry, guys. If you're logging in and you can't hear me, I don't really know what to say. I've got multiple people that are telling me that everything's working. It shouldn't be streamed on a separate site. You can go to pressstartlegal.com on the Ask Me Anything, Ask a Lawyer section. And there is a stream of this video that's playing. If you guys are having issues hearing it there, if you click on the video, it should go directly to the YouTube stream page. That might work a little better for you. Maybe switch your browser, change your settings. I'm not sure. Anyhow, new question came in. Should I start a limited liability company, or LLC, before I post any games to Steam, the App Store, or Google Play? This is a great question. I'm assuming that this individual is a solo company, a solo developer. Because if you're not, and you have, say, employees or contractors, and you're paying these individuals, I would hope that you have a company already started. But let's assume he's a solo guy. He's working in his basement, and he's created the best product of his life. He's ready to put it out for sale. What do you do now? Well, if you do not have a company or you're not incorporated, do it. Get incorporated. You can either do it with your local jurisdiction, your particular state. You can incorporate in Delaware. We discussed that earlier in the stream. After you do that, you get an EIN number and you go to the IRS webpage and you file for your tax ID number. And once you get that tax ID number, you go open up a business bank account. Then you then post your game on Steam, on the App Store, on Google Play. You make sure that you have a great terms and conditions or terms of services we discussed earlier in place. Make sure you got an end user license agreement. You want to protect you. That's what those two documents do. That's what forming the corporation does. You want to make sure that you have multiple layers between you personally and anyone else that could come after you. Okay. This is not really a video game created question, but it's relevant to video games in general. A Twitch streamer writes in and asks, Can I get in trouble for playing copyrighted music on my stream? So, sorry, that was someone else telling me the audio works. Can you get in trouble for playing copyrighted music on your stream? Yes. Yes, you can. Absolutely. Can you get in trouble for playing copyrighted music on your stream? The reason for that is you don't own that music. Plain and simple. No one has given you the right or the permission to play that music on your live stream. You are also even profiting from playing that music. So that creates another layer of issue. So that is 100% copyright infringement, playing music on your stream that you don't own a license to. How do you get around that? If you Google music licenses, there is a company called BMI. They're probably the most expensive, but there are other services out there where you can get either royalty-free music, you can get licenses to play music on your stream, you can get licenses for your games, you can get licenses for your YouTube videos, but do not use someone else's song that you either do not have a license for, that you did not pay for that use, and that is not a royalty-free song. Other than that, have at it. Okay, what is the legality of homebrew games? Not a fan game, but an original work designated to run an old video game console, not officially licensed by the creator of said console. Okay, this is a good question. Homebrew games. So, for anyone who doesn't know what a homebrew game is, a homebrew game is when somebody does not own the actual rights sorry, someone else sending me a personal message saying, it looks like you're trying to address your viewers, but they cannot hear you. Open your stream on another device and check yourself. Sorry, figures that the first stream has problems. Open your stream on another device and check yourself. I can hear it. Don't know what to tell that guy. Back to your question. So a homebrew game is a game that somebody is creating for a particular console that they do not have a license for. And this wouldn't be the case for, say, a PC. Almost anyone can make a game for PC. But let's particularly talk about old consoles. So I'm assuming we're talking about the old Nintendo systems. We're talking about Nintendo 64 and whatnot. I'm not actually familiar with the legality of that. So if particular companies, Sony, Nintendo, Microsoft, have strict regulations, rules that state that you cannot program a game for this console unless you pass these guidelines, then yeah, you'll probably run into some problems here. If you're creating a game that doesn't use any of their licenses, and you can do so without, say, getting pirated development tools, but you have these development tools, you got them from a legal source, and you're creating a game on an older console, as long as that game doesn't break any of the code, it doesn't circumvent any things that the creators put in place, there shouldn't be much of a problem here. If you're starting to sell these things, it might become an issue. Right now, if you want to develop, say, for Switch, Xbox, PlayStation, Sony, Microsoft, Nintendo all require you to pass through a certification. A lot of the times you're going to be paying royalties for your games that you create on these systems. So unless you're going to be requiring some sort of jailbreaking software to use your particular program, I think you're going to be okay as long as you're giving it away. So someone writes in, weird, the other YouTube link didn't work. Hello. Are you the guy who's messaging me telling me that my sound's not working? Because it's working. All right, next question. Somebody writes in, is there anything they should be concerned about when using open source tools in regards to commercial production? Yeah, there's potential issues there. So open source can be created in all different particular ways. And you need to make sure that every particular tool and line of code within that open source product is actually open source. A lot of the times people can sneak things in there. GitHub is a great example. You can find people who are, saying that they're giving away something for free, but in reality, they're using code from other people to create something else, and they never got the licenses or rights from those other individuals. There are open source licenses out there that you can use. There is such thing called a CLA. It's a type of agreement that you can then sign, that if you're going to be using code from an open source and contributing to that open source, you can sign one of these agreements, and that means you retain those copyrights while applying it to this open source agreement. But if you're using something in a commercial purpose, best to stay away from open source. Get a license to the particular engines you're using. That should help significantly. Someone's writing in. Oh. Yes. Next time I will look into Open Broadcaster project. I actually have open broadcaster project on this computer. It was not functioning, and I had to switch it to this Google Hangouts. So sorry about that. Maybe next week everything should be, or not next week, sorry, next month, these kinks should be hopefully worked out. So let's get back to questions. So somebody writes in, if I'm unable to afford forming an LLC or filing a trademark, should I be worried? Well, should you be worried? Anytime that you're entering a business and you're doing it on a personal level, you should always be worried and concerned. There is no level of protection anymore now between you and the business. So yes, you should always be worried. This might sound a little harsh. If it does, I apologize to this individual in advance. Everyone's economic situation is entirely different. If you're truly serious about going into business and making game development and producing video games and selling video games, get a job, get some income, put money aside each week until you can afford to file, get your LLC. Trademark, not so important in the beginning. Getting that company is. From there, create your games. Get something out that people enjoy, people will pay for, and then you'll have extra funds to do things like file a trademark, file copyrights, which are at these early stages, some may argue, more important, making sure that your codes are protected and whatnot. So if you can't afford even a basic thing like filing for a company, this might not be the right time for you then to get into this industry and this type of business, or any business for that matter. Okay, I want to make an adult game very sexual. Is there anything I need to worry about? Getting sued by parents. Okay, so you want to make a very sexual adult game. Can you get sued by parents? Well, theoretically, you're going to require individuals to be 18 to purchase that game. You will probably have to go through the rating board. You're going to get a 18 and up requirement on that. So if you're looking to go into a retail store, they're going to be the ones who are going to be the judging whether or not you, as a purchaser, are of age to buy that product, and you shouldn't worry so much on that side. If there is some sort of failure during that operation, well, you have potentially a defense against an angry parent suing you that their under 18-year-old kid has a porn video game. On the other side of that is online. For example, Steam just amended its requirements, and now you are allowed to create and sell adult games on Steam. Steam has the obligation to ensure that the purchasers who are buying these products on their platform are of age and able to do so. That's not your particular worry. What you can do to protect yourself is have an end user license agreement, have terms and conditions and terms of service that clearly lay out the facts that your product are intended for people 18 and up. And if you are not 18 and up, you are not getting a license to use this product. That will go a long way in protecting yourself. Good luck on your game. Okay, someone writes in, I want to ask about how legal it is to upload a game on Google Play Store or any stores that don't really force you to represent yourself as a company. Is it illegal? Okay, if I don't. Okay, so is it legal? Okay, if you don't. It depends solely on what those particular stores require of you. Now, what I mean by this is it is very possible, without fully reading the requirements of all the outlets that you want to place your product on, they might require you to actually incorporate. If they don't, then yes, it's legal. You can go ahead and do it on your own. You would essentially use your social security number as your EIN number. You would represent that you're an individual. You're doing this through an individual capacity. You're still going to have to pay taxes on the income that you're going to generate from the sale of that game. And I would strongly advise you speaking with a tax expert on such. But can you do it? Sure. Is it illegal? No. I would always check to see what those particular stores require, and if they don't require for you to be incorporated, go for it. All right. I want to name my game after an obscure world. I want to name my game after an obscure word that's in the dictionary, but it's also the name of a large, well-known international watchmaker. Would I be at risk of infringing on their trademarks? Okay, Elliot, great question. I was hoping that someone would ask something like this. Let's talk about trademarks. Trademarks have classes of goods and services. So when you register your trademark, you're going to fit in one of these particular classes. For example, I had a question that came in earlier today of somebody who wanted to get a trademark for their band name. And with bands, you have a class for live entertaining music. You have a class for recorded music. You have a separate class for the sale of t-shirts and merchandise. And you have a separate class for printed goods like posters. So he could theoretically get his band name as a trademark in all four of those classes. To your question, it's possible, and it would require me to actually do a little research on the particular watch company that you're looking at. But as long as they didn't register in the particular class of goods or services that would be for a video game, and I need to double check this, but I strongly am pretty confident that jewelry, watches, rings, bracelets, necklaces, etc. are in a separate class of goods from video games, which are an entirely different set of goods and services, I believe. Again, need to check that to be 100% sure. But you could at least attempt to file a trademark. Would it be infringement? That's another issue. You would be in a separate class of goods. They could claim what's called likelihood of confusion. There is a laid out set of factors that you would have to then apply to your particular situation. And if at the end of looking at those factors, yes, they could still maybe move forward with infringement, not necessarily infringement, but that you are causing a likelihood of confusion among those goods. My advice would be to avoid that particular name, but there is a chance that you could at least get the registration and then see what happens afterwards. It's entirely up to you on that risk standpoint. Okay. Next question. Am I able to use game music from abandoned games from developers that are no longer in business? Okay. This is another copyright question. So a copyright is good for the life of the author plus 70 years. So it all really depends. Abandoned games, even though the game is abandoned and the company is no longer in business, it is possible, again, I don't know with these particular facts that you're presenting, that the rights in the game's intellectual property were sold off to individuals or were kept by the people who formed the initial company. So can you use the music from it? If that music was created at that time by that development studio, or they have the rights to that music that's in that particular game, and even though that studio no longer exists and that game is abandoned, those rights aren't abandoned and they still own those rights to that music. So no, even though the game is abandoned, even though the development studio is no longer in business, I would strongly advise that you cannot use that music. Hope that answers your question. Okay. Question. Do I have to register the name or title of my game before releasing it out on Steam, Google Play, App Store, and itch.io? Okay, similar to what we were talking about, you want to, if you can, trademark the name of your game. It's branding, people. This is your brand. You want to protect it. Theoretically, you want to release sequels of this game. You want to build an entire fan base around this game. And you would hate it if a competitor decided to release a game with the exact same name and hurt your reputation with it. So protect your brand. Trademark your names of your games, trademark the logos of your studios, trademark the names of your studios. Just filing and incorporating your company does not give you any rights over the name of your company. You want to trademark it, create a brand. Brand yourself. Very important. Okay, someone writes in, are there any rules of how you can portray a celebrity or political figure in a video game? Can you legally do it? Okay. I know what everyone's sitting here probably thinking is, hey, it's fair use. I can do it. They're political figures. This shouldn't be an issue. It is. And it is because there are rights of publicity that are on a state level, and it would require a state-by-state analysis for where you're going to display that particular individual's likeness, and they have a right to be able to not be in your titles or your games. This was a big issue. If you guys remember, in Grand Theft Auto 5, Lindsay Lohan sued because they stated that they modeled the character, the blonde celebrity that was on her phone and acting very drunk. After her, there was an argument saying, no, this could be anybody, anyone in this particular setting of Los Angeles. You know, have you been to LA? But they used particular nuances. They used takes on her name that really showed that, yeah, sure, this character might not actually be named Lindsay Lohan, but in all intents and purposes, it is. So again, state-by-state analysis. Another big case that is along the lines of rights of publicity. If you guys all know, if you're fans of football, you cannot play NCAA college football anymore by EA. And that was because EA was sued due to rights of publicity when they would model particular football players on the college players. EA states that, no, this was very generic players, but they would go out of their way to, even though the name has changed and the number might be changed, create avatars of existing players on teams that would have a very similar animations and playstyle as their real life counterpart, along with the modeled jerseys and the school logos and school colors and the stadiums. It all created this belief that this is still this particular individual. And because of that, again, right of publicity cases on different state levels, you can no longer play NCAA football on the computer or on Xbox, PlayStation, etc. That's why that game no longer exists. Now, there is rumors that this is coming back, but who knows? All right. We've got about 15 minutes left. We're going to 8:30 Eastern time. Get your questions in. This is Press Start Legal's Ask Me Anything live stream. My name is Zach. I am the founding partner of Press Start Legal. I said this earlier in the stream, but I'm going to say it again. This is my general advice. This is my disclaimer. This is what I have to give. You know, we are not creating an attorney-client relationship. This should not be considered legal advice. This is guidance on particular issues. Everyone's facts are different. I strongly advise that you speak with an attorney about the facts of your case. You can email us at info@pressstartlegal.com. We will do our best to get back with you as quickly as we can. All right, got another question. Is it possible to avoid or mitigate the exorbitant fees associated with creating or owning an LLC in California? Perhaps another way that one can protect themselves without it costing so much. Okay. Oh, and there's a Bethesda versus Warner Brothers question that just came in after that. Kind of excited about. Not that your question, CM, is any less important. The issue with that is I do not know California state law, so I cannot comment on what the fees are for California LLCs. We talked about this earlier in the stream. You can incorporate in almost any state, and then you can register in your home state as doing business in that state. For an example, Press Start Legal can go out and incorporate in Delaware, which is a very popular state for startup tech and startup companies and even large companies to incorporate in for a number of different reasons. And I can still register in the state of Florida as doing business here, but not be a registered business in the state. That might, depending upon the particular state you want to incorporate in, lower those fees. But yeah, I don't know what the California registration fees are for an LLC. All right, Bethesda versus Warner Brothers. Are there certain protections a developer or artist should take into consideration if they decide to consult for studios, but before releasing a game? So there is a non-disclosure agreement that Press Start Legal has that we're about to include. Great opportunity to announce it. We're going to be putting out relatively soon, once we finish designing it and figuring out what we're going to put in it. It's a very basic free startup kit. And it's going to have, as one of the items in there, a non-disclosure agreement that you guys can use. It's going to be extraordinarily basic. I can't stress that enough, basic. And you still want to consult with an attorney before using it. But we are going to give it to you and you can use it at your own risk. They're going to have particular checklists like the intellectual property checklist, things that you should be doing while you're getting started, things like incorporating, making sure that you're incorporated, going to that particular state. We'll talk about the differences between them. We'll also throw in a CLA agreement, but really basic stuff. Just enough to get you guys started. So back to your question, you can use a non-disclosure agreement to discuss things with different developers or studios before releasing a game. More on the issue of what happened with Bethesda and Warner Brothers, they hired Behavior Interactive in Montreal to create Fallout Shelter for them. This was a recent blog post on Press Start Legal. We were discussing work for hire and assignment of rights. Within their agreement, they got an assignment of rights that assigned all the rights in the copyrighted material that Behavior was creating, so the game, the code, everything, over to Bethesda, and Bethesda became the sole owner of all those rights. What then ended up happening was Warner Brothers came in and hired Behavior to create Westworld Mobile. Now, without knowing more facts about the case and only going off of what was filed in the courts, based on that information, what appears to have happened was to cut development costs. Behavior used its knowledge and access to this Fallout Shelter code and then created Westworld Mobile for Warner Brothers. So in that particular situation, Bethesda did everything that they could do to protect themselves with the particular agreements that they had in place, and that gives them that legal remedy now to go after Behavior games. We got some questions coming in. So yes, you can get a non-disclosure agreement. Now, I have to warn you that there are a lot of times that studios will not sign your non-disclosure agreement. And the reason that they don't want to sign it is not because they're looking to rip you off, but because if down the road they release a game that is similar to the one that you discussed with them, they don't want you to be able to sue them. It's not because that they actually ripped off your idea, which it could be possible. So don't get me wrong here, but let's just say that someone new came into this particular studio and said, this is the game, guys. This is going to put us on the map, and creates a game just like the one that you pitched 2 years prior, but they don't want you to be able to sue them for that. And that's why a lot of them may not sign your non-disclosure agreement. We have some questions coming in from Reddit. I thought we did. What are the chances PUBG winning against Fortnite in a legal battle? Chances are 0. There was a very small chance that Bluehost could, sorry, not Bluehost, that Bluehole could have prevailed against Fortnite in their copyright infringement case, simply because unless somehow Epic stole code from Bluehole, and I didn't read the full complaint that was filed in the South Korean court system, but if this case was put in the United States, just because the concept of the battle royale is the same. You're up on a bus, you jump out of the bus, you're against 100 players, you're picking up weapons or salvaging items. The fact that they didn't use any of Bluehole or PUBG's copyrighted works, there's no infringement there. You cannot copyright or trademark a game concept. If they did, the gaming industry wouldn't exist. This question's been brought up actually quite a bit, and what I give as an example would be how many Candy Crush clones were there? How many Clash Royale clones are there? How many times has a game like Call of Duty and Battlefield taken elements from each other's games? You cannot trademark or copyright or protect a game concept. You can certainly try to be first to market with a fresh new idea, but you cannot protect that idea or that concept. Question came in: if I'm selling services or products in a game, is the new state tax law on online sales going to affect my sales? Fantastic question. Don't know the answer to it. In fact, I consulted with a tax attorney a few days ago about this. My concern was for a particular client, they were selling microtransactions in the game. In the game, the items are, they're goods. They're, sure, they're digital, but they're still a good. And my questioner would the company then have to take sales tax? What I can tell you generally about the issue and about the new Supreme Court holding, all that case did was more or less open the floodgates. There were a significant amount of retailers already accepting online sales tax. What this particular case did was allow for that particular state to enforce a sales tax law that allowed that removed, the physical nexus rule, which basically, in a nutshell, was the company needed to have an actual physical nexus in the state to collect, and then have to be forced to collect sales tax. So, for example, in Florida, for a while, Amazon did not have a fulfillment center here. Now they have about 3. And now that they do, you get charged sales tax regardless of that particular law. So that's going to be also a state-by-state analysis. Let's check Reddit. We got a few more questions coming in. Oh, no, just people telling me that the sound is working. They were just on the wrong link. Sorry, guys. That's YouTube for you. Next time we'll probably be on Twitch. It works. I know it works. Yeah. Sorry about that. All right, we're back. So we got 7 more minutes of the Press Start Legal inaugural Ask Me Anything. I am a lawyer. I'm a video game lawyer. I am the founding partner of Press Start Legal. Go to pressstartlegal.com. Email me at info@pressstartlegal.com. Any questions you guys have, we are here to provide legal services to the game development community, to the indies, to the big boys, everyone out there who is involved in video games. We want to meet you. We want to represent you. We're here. We exist. Okay. somebody is writing in. I don't really understand his question. Somebody sent it in on Reddit. I'm sorry, I'm not going to be able to answer that. Didn't really make a lot of sense. Okay, somebody writes in, if me and a friend are building a game for fun and learning without any serious plans of selling the game on any of the marketplaces, but if things were to go great and we decided to sell it, building it off into an actual marketable, sellable game, are we going to be in a rough spot if we use non-commercial software right now? If you're planning on using that software for commercial use and you have a non-commercial license, I think the answer is pretty clear there. Yes, you're going to run into a problem. Get that commercial license to use that software if it's available. If not, look for new software or just have fun and don't sell your game. As soon as you do, commercial purpose, you're going to run into an issue. For those with mailing, okay, here we go. For those of us with mailing lists, and only mailing lists, no complicated data harvesting, do you have for a dummy's guide to compliance with the GDPR? Okay, this is a great question. So let's kind of break this down into the most simplest way that I can, because the GDPR is a very complicated bit of privacy law. If you guys out there are US-based companies, remember, we're only talking about US law right now. If you are a US-based company and you are marketing your services to EU citizens, people in the European Union, you are going to have to comply with the GDPR. There is a ton of different requirements that you're going to have to put on your terms of service and your privacy policy. You're going to have to be able to remove users from that list completely, remove their data collection, etc. If you are a US-based company and you are only targeting people within the United States or anyone outside of the EU, you are within the safe harbor provisions. Again, this is a very general because this might not actually apply to you when you think it does. When I mean you're in safe harbor, if somebody from the EU just happens to stumble upon your website and signs up for your mailing list and their data just happens to be collected by you, you would be under this safe harbor. But again, this is only in very particular circumstances, so it's best to consult with an attorney about your particular facts. Complying with the GDPR is going to be a bit of a nightmare for individuals. Now, I don't know what mailing list software you're using, but I know that Constant Contact and MailChimp has recently changed their policies and the way that they do things to be GDPR compliant. And there are options when a user unsubscribes that same user can actually click to have their data removed from MailChimp and from Constant Contact, thereby making you somewhat in compliance by having that service. But again, you still need to get your full privacy policy and terms and conditions in order before you can be fully safe and safe with some regard. I think we got time for one or two more questions. Throw them in the chat. We're getting them also on Reddit as people are writing in on our various posts and sending me messages directly. I haven't gotten anyone else writing me that their sound isn't working, so fantastic. Somebody writes in, what is the difference between a privacy policy, a terms of service, and an end user license agreement, and when and why do you need all three? All right. This is a great question because it builds off of what we were just talking about. Let's start with the privacy policy. Like we were saying, your privacy policy governs how you collect and utilize data of your customers and the visitors to your website. Your company must comply with that particular policy. In the United States, there are several governing bodies that oversee the laws and the regulations regarding citizens' privacy. And one of the biggest, I would say, mistakes that companies can make is you create a privacy policy that details how your collection of data will work, how you collect cookies, you collect geolocation, you collect emails, you collect IP addresses, etc. Especially if you're using Google Analytics on your website and you're not following those procedures, you're going to find yourself in a bit of trouble. A lot of the time, certain analytical software won't even allow you to install it on their website without these privacy policies in place. Terms of service, we discussed about it earlier in the live stream, but in case you weren't here, we'll talk about it again. Terms of service governs the terms of the services that you're going to be providing to your customers. A lot of times, especially if you're an e-commerce website, it will govern credit card collection, it will cover returns, it will cover just about anything that you can think of that revolves around how you provide those services to those particular individuals who are purchasing said service or products. And then your end user license agreement, as you guys know, or you might not know, or might not be aware of, when you purchase software, or in this case, video games, you as a purchaser are only purchasing a license to use that game. And that license comes attached with a lot of rules, terms and conditions, terms of service, and a lot of those details, such as use of the copyright, has to do with non-circumventing the particular code. If you're installing software on an individual's computer without their actual knowledge, it would be detailed in that license agreement, such as using BattlEye, etc. Your end user license agreement is your contract between the players of your game and you, the creator of your game. Another great one, it will allow you to ban users' accounts for cheating in your game and not allow them to have a legal recourse against you. This is a guy who spent, or a woman who spent $60 on your product, and now they can't even play it. Well, that's because they breached their contract, in essence. And you would use all three for those particular circumstances. You want to have all three. For your website, you want to have your privacy policy, your terms and conditions. For your video game, you want to have your end user license agreement. Somebody writes in on Reddit, if I'm making a farm simulator and I'm using John Deere tractors in it, do I need to pay them if I don't include their logo, but the tractors kind of look the same? This is a great question. So, can you use the tractors if you don't? If you're modeling, hang on, put that aside. Does John Deere have copyrights on their tractors? It's certainly possible, without digging deeper into the copyright office, to determine that they probably have a copyright on the tractors. They probably have photos of the tractors. They most definitely have photos of the tractors. They're probably using those photos more likely than not. Probably guarantee that they are. So that's how they can create a copyright for a physical object. They also probably have patents on those objects, but that really might not affect what you're talking about in this question. Now, you don't really have to worry about trademark, although, and again, I'd have to look at this, that green that you see on all of the John Deere tractors could be a trademarked color. So if you're using that green, you could be theoretically, you could be theoretically infringing on that trademark. Now, to sum it all up, let's assume they do have a copyright on the tractor. You're putting that tractor in your game. You're creating what's known as a derivative work of that tractor in your game without a license to do so, regardless of whether or not you're using their logo. And if you're going to make it green, you're creating something that almost identically resembles that tractor. So you will have problems. And I would say that you're going to want to stay away from modeling anything to that level of detail. Now, you can put a tractor in your game. You can come up with a funky name for it. You can even somewhat, and I'm talking very minute, resemble something like the John Deere tractor. Do not use that color green, and it just looks like a tractor. Chances are you'll be okay then. But I would have to really see what it is you're making in that circumstance to really give you a bit of legal advice. But the further you create something that does not look like a copyrighted object, the better you're going to be. Don't steal people's copyrighted stuff. Plain and simple. All right, so it is now 8:33, and we are going to bring our live Q&A to an end. If you have any last questions, the first person to put a last question into the chat will get it answered. I know that there's a little bit of a delay right now between my voice and the chat. Sorry, that's YouTube. But again, last question. Who's got it? We got a question that came in from Reddit, but I said the chat. So the question that came in from Reddit is it legal for me to rip a ROM from a game? I personally own some console that I own and then use it to emulate it. No. Okay. Guys, creating ROMs, you're creating a derivative work or just straight up copying a game that you don't have a license to do so. That is going to run you into some problems. And for that, that is my last question that I'm going to be taking, guys. Thank you so much for attending the Ask Me Anything. I'm a video game lawyer. Please visit pressstartlegal.com. Send us an email at info@pressstartlegal.com for any questions that you guys might have. You can always hit us up on Reddit. Our Twitter is @pressstartlegal. We have a Facebook page. Just search Press Start Legal. Again, everything you guys heard today, this is my opinion. This shouldn't be treated as legal advice. We do not have an attorney-client privilege. And thank you very much for not saying any confidential information about your products, your games, your companies in the chat. We will be back at the end of July. In the meantime, talk to you all later.